Bismillahirrahmanirrahim. Assalamu alaikum. I'm Khalid Iqbal, and here we talk about evidence. Evidence plays a very crucial role in the administration of justice. Evidence comes from the Latin word evidentia, which means clearness or obviousness. It is derived from the word evedere. It means to see clearly. So, evidence is a something that is clear or obvious. We can define it that evidence intends to clarify, to prove or disprove a fact or assertion. Black Law Dictionary defines evidence as it intends to prove or disprove the existence of an alleged act. According to the Shahdat Order 1984, Section 2C, evidence is that statement that is presented in the court in front of the judge on oath, or document presented to the court to examine it. Evidence consists of testimony, documents, real evidence, or where it is admissible, the hearsay evidence. Evidence has a very ancient history, and in the ancient civilizations there was testimony of physical proofs and oaths which were taken as evidence, and in the Mesopotamia and ancient Egypt there were rudimentary methods to determine the guilt or innocence. In the Islamic era, evidence has a very important role in the administration of the justice, and evidence traces back to the times of the Holy Prophet Hazrat Muhammad, peace be upon him. And evidence was the foundation of the administrative and judicial system of the Islamic society. And in Islamic community, oaths, confessions, testimony, and intangible proofs were taken as evidence. In the Middle Ages, there were ordeal trials and combat trials to determine the innocent and guilty. It was really inhumane method to determine the guilties and innocent people. So with the passage of time, there were evolutions, and in the Renaissance and enlightened ages, there was reasoning and evidence determining criteria evolved over the time, and now there was new methods, and especially the Roman legal system played a very vital and key role in reshaping the and reforming the evidence system. Now, there are specific rules to present evidence, to collect evidence, and evaluate it. And now, in this modern era of the technology, there are new techniques, new rules, and it is age of digitalizations. Now there are forensic and digital evidences to determine the uh, truthfulness of some fact, and now it is now sophisticated and modernized techniques that are based on reasoning. So in this world, in every judicial system, these evidence parameters are little bit different, but their genesis and their genre is the same, which is based on the realities, which is based on unbiasedness and fairness to provide the justice and determine guilty and innocence.